All right. Welcome, everyone. My name is Wendy Venverlo. I am the Executive Director of NAPSA, and I will apologize in advance. I feel like my network connection's a little slow today, but luckily I'm not the one that's talking for the majority of the time. So thank you all for being here. We're super excited to present this webinar. This is one of the sessions that we would have held at our conference last September on Wednesday morning that had to be canceled due to the hurricane. And so we're excited to be able to bring you this content about supervising individuals on pretrial release. I do have we do have a webinar coming up here on March 6th at 10:30 a.m. Central Time. That is on the NAPSA pretrial standards and the revisions in 2024. So I will put that in the chat. But otherwise, just want to thank you for being here and turn it over to my colleagues who are going to present the session. And so, James.
Good afternoon to some and good morning to others. My name is James Owens. I am the program manager here in Mecklenburg County, which is Charlotte, North Carolina. I have been in the pretrial field for about 10 years now. I've been in my role as program manager for right at 2.5 years. I'm glad to be able to present this. I was looking forward to doing it at NAPSA in person, but glad that Wendy was able to provide this platform for us to deliver this workshop on supervising individuals. And that is it for me. I will throw it over to my colleague, Kellie.
Hi again, good morning and good afternoon. So my name is Kellie McBride. I'm just honored to be able to present this. I had been looking forward to, as James said, presenting in New Orleans, but glad to be able to make it up and do it now. So Kellie McBride, I have been a board member, the Northwest Regional Director, board member of NAPSA for 1 month now. So I'm new to the board, but I'm not new to NAPSA. In December of 2017, the voters of my county mandated that our county create a criminal justice services department. And one thing that they wanted to make sure we had in that department was a pretrial services program. That dovetailed very nicely with the state of Montana selecting our county as one of 5 pilot counties to utilize the Arnold Public Safety Assessment, or PSA. So all of those things kind of happened. It was a perfect storm, and it kind of felt like a storm at times. We also had some technical assistance from Arnold. And with that technical assistance, I was encouraged to look into NAPSA, to join NAPSA. And I did. I went to my first NAPSA conference in July of 2018 and just met some incredible people. The resources were amazing and the standards. So we started our program really relying heavily on research and relying on the NAPSA standards. So I'm excited to present today. Oh, do we have this? Are the slides up, James?
Yes, I am getting ready to share them right now.
Sorry, I went through the first one already.
Hey, Wendy, you have to give me the rights again. I thought we had it. Gotcha.
You should be co-host. I apologize for that.
No problem. There we go.
Okay, so you've met me and you've met James. So we can go to the next slide. So session overview, just again, the legal foundations, we're going to talk about those and the standards. NAPSA did release new standards. That 2024 standards have just been released. So I encourage, if you haven't looked at those, definitely look at those or attend the upcoming trainings on those new standards. We're going to talk about the principles of pretrial and also the research behind pretrial. As I shared, our program, there was a lot of research that went into designing our program to make sure it was evidence-based. So I like this slide a lot. Are we promoting success or are we managing failure? And what is success? So when we're looking at pretrial services, we're really looking at that. Are they making, is the individual making it to court? And are they staying arrest-free? Those are the two things that really determine success. There's other things throughout, but what we're really measuring, what we really want to make sure they're making it to all their court dates, and that they are not, that they are staying arrest-free. Next slide. Yep, that was quick. Okay, so when we're supervising, providing services, however you want to term it, the first thing is to be the least restrictive. We want to make sure that we're not over monitoring or we want to provide those services in the least restrictive way so that that person can succeed. The court date notifications, that's a big deal. And I think if we think about notifications, that's how I remember to go to my dentist appointment or my hair appointment. I get a text message. So why not have that for those that we're serving as well? One thing I thought was interesting, James said that with those text messages, that wasn't really working in his jurisdiction. So the first is a phone call, a personal phone call. So I think, tailoring it to your own community, but you want to make sure that that you are definitely notifying folks of when their court dates are. When we started our program, we met with all of the judges and all of their staff and said, let them know that we were going to be sending out those court date notifications. And one of the courts, the clerk said, well, we really didn't need to do that because they mailed them out. And they did, and they were confident in that. We also recognized we had a lot of folks assigned to pretrial services that were experiencing houselessness, didn't have a good address. So if we can text them, we can make sure that they know when those dates are. And for our jurisdiction, court dates change all the time. So I'm guessing it's kind of the same way for you all as well. Pretrial justice trained staff. And I think that's super important. We're not probation. We're not in that punitive state. We're there to, again, help those individuals make it to court and stay arrest-free. And if we can connect them with services along the way, that's great. But making sure that our staff are trained. A great way to provide that training, again, I'll give another plug for NAPSA. We require that all of our pretrial officers are certified through NAPSA. Ours are officers. I know some places have case managers. State of Montana, pretrial officers they have to go to the law enforcement academy for 6 weeks. So they are trained in pretrial specifically. Oversight of an individual's compliance with court-ordered conditions. We want to make sure that we're going over those conditions, that the individual knows what those conditions are. And if you think about being in court and hearing a judge list off things that that judge wants you to do and how stressful that time is, that's a great opportunity for that pretrial case manager or pretrial officer to really visit with the individual and explain what those court conditions are. Our officers will do some role playing as well. Sometimes that helps. If there's a no contact order, the officer will ask the individual, hey, so you've got a no contact order. What happens if the other person sends you a text message? What do you do? And have the individual explain it to make sure that they understand what that no contact order might be. Notification to the court of new arrests. We always want to make sure that we are notifying the courts and whoever may need to know of that. If recommending lower or higher levels of supervision. We don't have that ability right now in our jurisdiction, but I know there's some out there that do, and I think if there's a possibility if you're working with somebody and request that those the monitoring be reduced, that I would advocate for that, or increased, I think would be important too. And then facilitating the return of individuals to court when they miss hearings. Part of that's on that relationship. You have a good relationship with the individual. If you have a good relationship with the courts, it's easier to facilitate making sure that person does go back to court. We have had folks who our officers will walk them over to the courthouse, and they can present there and get it all figured out. But again, that goes with that relationship building. So that's it on my NAPSA, and I'll go to the NIC. Sorry, I'm looking down, so I make sure I hit all of my notes here. So the risk principle, so when we look at that risk principle, supervision levels that match an individual's assessed risk level, it's one of the things I like so much about the public safety assessment. It gives a data-informed risk assessment. Is this person, what's the chance that they're going to make it to the chance that they're going to make it to all their court dates, the chance that they're going to stay arrest-free. Pretrial risk assessment tools are not designed to replace the judge's discretion. I just want to be very clear. The judge always has a discretion. Those risk tools are there to help the judge with the judge's decision, but in no way are they meant to replace the judge's discretion. Supervision should include, and we already talked about, court notifications, response to individual conduct, prompt notification of violations, making sure that we're communicating with everybody. It's that relationship building across the system. And then on special services and interventions, so treatment, housing, et cetera, that's where we know that those two things we're really looking for in success are they're making it to all their court dates, they're staying arrest free. But I think sometimes we have that opportunity to help someone that might need additional assistance. And one example I'll give, so our judges will assign additional drug testing for individuals that they feel random drug testing is merited. We don't do the drug testing here. We work with different places in the community that do drug testing. One site that we work with gives a reduced cost. We pay for the first 2 weeks of any drug testing while the individual gets themselves, caught up and set up. But one of our officers realized that in Montana, if you are in treatment for a substance misuse disorder, and you have Medicaid, Medicaid will pay for the testing. So that's been a way for us to kind of encourage folks who may be on the fence whether they want to enter treatment or not. If we can get them to get into treatment, that Medicaid will pay for that random drug testing. So just kind of a nice way to plug people into services as we move along. Now, the 4 principles of pretrial supervision. So we have the law. I just want to make sure I hit everything. The law, data research, and best practice. The law, it's going to be a little bit different in every state and every jurisdiction. I've even noticed in Montana, it's sometimes can be a little different depending on what county you're in, how that's approached. But it's just part of the puzzle pieces that make up pretrial supervision and how we can do that. Then we have the data, and the data tells us that honestly most people succeed when they are pretrial, and the best way to help them succeed is to not have them detained. Nationally, about 80% of people released appear for court and do not get arrested while on pretrial. So we're really starting at a high percentage. And I think that's important to recognize. Most people do succeed. With pretrial services, we can increase that even further. The research tells us that we should provide fewer pretrial resources or none to those who are at who are assessed as more likely to succeed. And I do like that term, more likely to succeed, versus how we said it previously, that risk level. We're talking now more about success. And we move on to the buzzwords. So least restrictive. We've talked about that quite a bit, and we'll continue talking about that. We do want to be the least restrictive with those that we're providing services for, that we're supervising in pretrial. And when we talk about least restrictive, there is some legal basis for that. If we look at Salerno, Salerno said that I want to say it perfectly, so I'm going to look at this. Held the conditions of bail must be set at a level designed to assure a constitutionally valid purpose and no more. So we want to make sure that the individual that there's community safety. And that would be the only reason to really detain. Otherwise, we want to be the least restrictive. And with this, we're talking about least restrictive with, this was with cash. Conditions should be used sparingly and only when necessary. This concept of least restrictive conditions appears in the federal and District of Columbia statutes and American Bar Association best practice and National Institute of Corrections and NAPSA. And then we'll move on to the next one, individualized. And I think this is really important. When we're working with individuals who are assigned to us, when we're providing that supervision, each person who walks through our door is going to be different. We want to make sure that we're honoring that individual and that we're helping them succeed. And again, helping them make sure that they make it to court and make sure that they are not arrested on a new charge. And I gave the example before about looking at that individual, would treatment be helpful? For some folks, it's not going to be. For others, it will be. And how can we work with that individual to get them into treatment? How can we ensure that that treatment is paid so that they're not further burdened? Again, the least restrictive possible. And if we move on to success-based pretrial, I really like that the NICs looking at defendant supports and also looking at mitigation. So if we're looking at mitigation, what are some of the things that are holding people back from being successful? Are they really missing court because they're being defiant and just don't want to go to court? Or are they missing court because they didn't have a ride or their car broke down or whatever that might be? So is there an opportunity for us to secure bus passes, or can we give them a ride? Can we, are there bikes that are available? We worked with our local law enforcement, Helena Police Department. They have bikes that they collect throughout the year, and they donated those bikes to our program so that we could give them to people to individuals who needed help with transportation so they could get to court. We also give rides and bus passes, but that's not mitigation, helping, looking at what some of those barriers are and then helping the person move forward. With success-based, looking at housing, looking at healthcare, mental health care, what are those supports that we can provide to help the person? Again, everything is individualized and not assumed. But we really want to look at the success, and we don't want that person coming back. So how can we help them succeed best during the pretrial period? And lastly, person-centered supportive pretrial release. Partnership with community-based services is so imperative. Relationships across the board within our criminal justice system, but also with those community-based services. So do we know who those folks are, that we can give a hot handoff and not just a warm handoff or a recommendation? It's always it's better when an officer or a case manager can walk a person over to a community service provider and introduce them to that staff, rather than just saying, hey, why don't you call this number and get some services over there? So really knowing who your community partners are. Our officers also go out and meet with all of the community providers. It's one of the things that we've agreed that makes sense, so that they are out in the community, they're seen as part of the solution and part of the community. That success-based model we talked about before, and really that's the success, the connections, mitigation, and then recovery strategies. That recovery it's focused on the individual and not the disease. So that ties it up for me. I feel like I've gone long. James, I'm going to turn it over to you, and looking forward to what you have to share.
I wonder if I could just interject really quickly.
Sure.
Yes.
James, did you notice, and Kelly, just to draw your attention, there are 2 questions in the Q&A, and I didn't know if maybe this would be a good time to look at those.
Yes. Sorry, Wendy, it won't let me pull the questions down. Can you read them?
I can read them. So the first question is from Daniel Cole, and it says, in reviewing release conditions with individuals, we are directed simply to read the conditions with them and refer any further clarifying questions to their attorneys. Are there concerns of interpretation when role-playing those conditions of release, and or how is or was that navigated? I can answer real quick, and then I'll, James, turn it to you and see how you approach that. With the role-playing, we have not seen an issue. If there are questions that are legal, if it's about the charges specifically, we do not talk with our individuals about those charges. We do refer them to their public defender or their attorney, and we're very clear. Don't talk to me about don't talk about the case. Don't talk about any of that. However, with the court conditions, which may be a no contact order, or no alcohol or drugs, or stay away from bars and casinos, those are things that we will talk through. The no contact, really, we just recognize that folks were not understanding. They knew that they weren't supposed to have contact with the individual, but then they would get a text message from the individual and they would text them back. So we just wanted to make sure that they understood that's not something that you can do, and we would rather head that off before it becomes a violation. James?
Yeah, I have nothing to add with that. I think, with us, we definitely review those conditions that are set by the courts. We highly recommend the individuals to follow those conditions, and we are able to supply the resources to them. But as far as following through, we on their visits, or when we have contact with them, we'll try to follow through with them to see if they have been to that service provider. And we will go from there. As far as the prosecuting witness, we do the same thing as you, Kelly. We let them know what they can and cannot do. We advise them that if the prosecuting witness is contacting them, to contact their attorney and let their attorney handle the situation from there. A lot of times, we have to let them know that even though you are staying in the same residence, you have to get a police escort to go out there, and we do provide that information to them, so they won't get in no further trouble.
And it sounds like it says this is very similar to what our case managers do here at Harris County Pretrial. That's from Rose Gonzalez. The next question is from Tracy Fisher, and she's asking, are you able to mandate someone go to treatment so that if they don't go, it is a violation? And for us, that's absolutely no. We cannot mandate anyone go to treatment. That's not our purview. We may recognize that someone would benefit from treatment. We may encourage it. We may suggest it, but really that's the person's decision, and we're not going to push it any further than that. We will help. We'll make those hot handoffs. We'll make those connections, but we will not force or push and definitely not mandate. Our courts cannot mandate someone enter treatment for during that pretrial period. So that's not something that we could do either. James?
And that is exactly how we handle those as well. We definitely, like I said earlier, we will highly recommend someone to do some services, and we will give them the resources to get there. But we don't mandate them to do any services.
Follow up on that question from Rebecca Bratcher. She said, in Lake County, Indiana, we cannot mandate a client to go to treatment, but we will ask the judge to order it while they are in our custody if they do have substance issues, or if the client is requesting to go. We can't allow them to until it is an order, and we would request it on behalf of the client, or their attorney would request it. We also have the ability to ask for it on their progress report. We have to file with the courts prior to the next court date. So I think that goes with we all do things a little bit differently. And so that's super interesting.
I think what's interesting for here in my jurisdiction is we do have some licensed clinicians on staff. So we do see, if we go up in the pod and we see that they may present some mental health concerns, we do rely on those professionals to go speak with them. Especially we can get them up there very quickly and have them to speak to them and give some recommendations. Again, we don't push those recommendations, but we will just say, hey, you spoke with this licensed clinician. They are recommending these things, and we will provide some resources for you. Or if you want to just when you want to just come back and talk to that clinician, if you have built that rapport, and that has seemed to work with us as well.
Nice. So do you want to take some more questions? I'm looking at the time, or should we?
Yes, we can go ahead and take some more.
Okay, so from Jennifer Wilcox says, I'm wondering about filing violations reports, notifying the court if a defendant fails to report to the pretrial office as directed. Are there NAPSA standards or best practices that speak to whether someone should have a violation filed for failing to report?
You want me to take that one, Kelly?
Yeah, you want to take that one?
Yes. I think the standard is just to notify the courts. And, if I think Kenny Spurgeon will put it best, if they're just not reporting to us and they're not picking up any new charges, or they are attending court, we will document it. We will let the court know that, hey, they did not show up, but we would not necessarily file for a revocation on that point in time.
I think that's perfect. And for us, we really work to get them here. So they may have an appointment, today at noon, and if for some reason they don't show up, our officers will make phone calls. They will go out in the community. They'll work to find that individual and get them in. So we give them a little bit of grace on that, but it's not a violation, but definitely a notification that they've missed. The next question is, what are your recommendations for supervising those who are homeless or transient? For us, we have quite a few folks who are houseless. We work with them really the same way we work with everybody else. We do have a limited number of cell phones. They're those track phones. So we purchased those in some minutes. So folks who don't have access to a phone, we can help them with that phone, so we can get them those notifications for their court dates. Our officers go over to the shelter. They know the shelter staff. We have a drop-in center. They know the staff there. So just really working within the community and knowing the organizations that work with the population has helped us provide services there.
Yes, I would agree. That goes back to partnerships with the community-based services. Trying to connect with your homeless shelters, kind of with your street outreach. You know, when someone is unhoused that is released from custody, you know, ask those questions. You know, they may not have an address, but you know, ask the question, what area do you frequent? So you know, you can possibly alert street outreach to say, hey, they are in this area. Can you touch base with them, and let them know of their court, you know, their court date, or have them to report to me to come, you know, to talk to me or anything like that. But what we have noticed also here in Mecklenburg is we do what we call a same day release. So if we have someone that is unhoused or is unable to give us an address, we will try to ensure that they get released on that same day, and we will connect with them and get as much contact information as we possibly can before they are. Once they are released, we will walk them from our detention center right over to our office and have that conversation with them right there. What we found is that has helped us a whole lot because we're able to build that rapport with them, and also to go ahead and start putting some resources in place with them instead of just letting them out and you know they're not coming back to see us.
Right. Is it preferred for pretrial service officers to notify the client's attorney if the client informs us they will not be able to make their court date? And for us, we would not notify it would depend. It would be very individualized, I think. If we had an individual who was really not doing well, there might be a chance we would with the individual, call the individual's attorney. The individual would talk to their attorney at the office, sitting at the officer's desk. And I have seen the officers do that. So the officer helping the individual make that phone call to their attorney. But anything that we let the client's attorney know, we also let the prosecuting attorney know, and vice versa. So anything we share with one side, we share with the other side. So it's better for us just to help the client or the individual make that phone call.
Kelly, I think some of the questions are going to be answered.
Okay.
You know, some of the comments in the comment slides. So we can, you know, we'll get through some more slides and we'll definitely leave some room at the end to answer some more questions for you guys.
Perfect.
So we're always thinking about promoting success, and how, you know, how can we have an individual to be successful while on pretrial. There are 5 different ways that we can promote success, and that first pathway is an assessment tool. You know, a lot of people do different assessments. Kelly has taught that, you know, her jurisdiction do the PSA. Here in Mecklenburg, we do PSA. I know some people have their own local assessments that they use, but assessment tools help to identify the likelihood of success for persons on pretrial. It determines the probability that an individual released during the pretrial phase of their case will reappear in court and not get arrested. Meaning for us, for like a PSA matrix, if someone scores a 2 on the new criminal activity and a 3 for the failure to appear, for us, that means that 85% of the time they're going to remain arrest-free, and 81% of the time they are going to reappear for court. The next pathway is using your local data. So if you're not using your assessment tool, using your local data to help identify how individuals are performing in your jurisdiction. And using that data, you know, all the time you're using this data, you're making sure that you inform your stakeholders of this data and how the probability of the individuals that are getting out of custody are reporting. And the probability is very high of them getting back to court and not reoffending. If you look at the national data states that, you know, over 80% of the people that are released return to court and do not get arrested. So that is some of those are 3 of the pathways that you can use for success. And also, you know, that, like I said, just informing the courts, informing your stakeholders of those numbers when you are, you know, you're approaching them for release. The The next pathway is individual supervision. So a lot goes into creating individualized supervision. These practices can be based on your jurisdictions. Like Kellie mentioned earlier, each jurisdiction is going to do things differently. Even though they can stay within the parameters of the NAPSA standards, things are going to look different in each jurisdiction. Some people may take different charges. Others may not, they may exclude some charges. And that can be like for us, for Mecklenburg County here in North Carolina, we exclude some charges, but in Wake County, which is about 2 hours away from us, they take charges that we don't take. But that is the tolerance of your jurisdiction. But these practices should be individualized, and we shouldn't penalize anybody for that. For example, if your jurisdiction has implemented a court notification process, someone that has a higher likelihood to succeed, you may not require them to call in but once. I mean, you may not call them but once for their court notification. But if you have someone that is less likelihood to succeed, you're going to possibly give them more multiple reminders. All of these pathways, they're important, and it lays just that foundation for us in the frequency and the intensity of our supervision strategies. By following the pathways, we ensure that supervision strategies, that we maximize the opportunity for pretrial success. And, last but not least on this is you can't manage and promote success if you don't measure it. So, measuring your success is very critical. Knowing your numbers is very, very critical. And I will say, knowing your numbers, if you haven't, looked at measuring what matters, Aaron Burdick did a session on that. I think it was right before Christmas, if I'm not mistaken. But it is on the NAPSA YouTube channel. I would, highly recommend everybody to go back and look at that so they can, start to figure out what things need to be measured and what things need to be reported back to your criminal justice stakeholders. So what does the research say? Research on pretrial conditions suggests that the least restrictive supportive approaches are more effective at ensuring court appearance and public safety than punitive or overly burdensome requirements. So what we do know is court notification improves court appearance rate. We do know that drug testing does not improve court appearance or new arrest rates. Supervision does not significantly improve court appearance or new arrest rates, meaning sometimes, we may over supervise, and some people don't need to be supervised. They have the least likelihood of getting rearrested or not coming to court. And if we are supervising or monitoring them more, they are more likely not to do as good to do as best as we want them to do. The electronic monitoring and GPS, there is no clear association with improved pretrial outcomes by using that. And I will go into some more details on that here briefly. So with EM and GPS, what the research tells us is, it's conflicting, meaning that, EM, some jurisdictions may see a bigger influx of success, but some may not. But overall, we see more increased technical violations, meaning, we have more charging violations, curfew violations, things of that sort, not things that that's going to measure success rate up of new criminal activity or court appearance rates. Low risk individuals are placed on these EMs, and when they're placed on the EMs, they were twice as likely to fail. Research on the intimate partner violence and domestic violence cases is mixed, and occupational stress is associated with EM and GPS monitoring, especially in the IPV and DV cases. So, what about the use of testing for alcohol or other drugs? There are several studies that have investigated where this release condition um, does not improve court appearance or law-abiding behavior have failed to show that it helps. Um, Reason being, the results are mixed, but drug use is a behavior and is not a risk factor. Um, it does not dictate that a person is not going to show up for court. And it does not dictate if a person is going to get rearrested during the pretrial phase. I will say in 2018, before 2018, we conducted drug testing on each individual that was placed on pretrial. In 2018, our stakeholders came together and we had a bail policy change, and we got rid of the drug testing, and we only drug test if a judge orders that the person be drug tested. And I would say since 2018, I have seen less than 10 judges order drug testing on an individual that was placed on pretrial. And we have not seen an increase in our, court appearance or our fades, our court appearance or our public safety rate. Actually, our numbers have gotten better since we have started doing that. Reason being is, you have those technical violations of, testing positive for drug use, and then we are now putting a person back in custody for that. The ideal is that we don't do drug testing, but in reality, we have to say that over 77% of the pretrial programs do drug testing, and the issue is the Fourth Amendment mentions unreasonable searches, and that is an issue when it comes to drug testing, and that's something that you should take back to your stakeholders. So studies show that cash bail does not greatly improve court appearance rates compared to non-financial conditions like court reminders and supportive pretrial services. Cash bail detains, as we know, low-income individuals who cannot afford even the smallest amount of a bail, while the wealthier individuals, regardless of their risk, are able to pay their way out of custody. Bail decisions often lead to systemic biases, leading to disproportionate detention of marginalized communities. So just to sum that up, financial conditions for pretrial release are largely ineffective and create significant injustices. Evidence-based, non-monetary approaches like court reminder calls, pretrial supervision, and supportive services are just far more effective in ensuring that an individual reports to court and maintain public safety. So in ensuring that an individual appear for court dates requires a lot of proactive and supportive strategies rather than your punitive measures. I like to tell staff here, start planning how someone is going to get to court on that first contact you have with them. Start to look at all the barriers that they will have. Hey, how is your transportation is going to look to get to court? You got court in 2 months. Do you have transportation to get there? If you don't have transportation, like Kelly said, provide them with a bus token or a bus pass. If it's better, you might want to say, hey, your court is 2 months away. So, is it better for me to, mail you a bus pass a week before court so you can have that bus pass? Start to think about them. If they have children, think about their child care. Who would be able to take care of your children, if you have to come to court? Now, some courts do have child care facilities in there. Mecklenburg is one. We do offer childcare facility in our courthouse, so they can, take their children to that childcare facility while they are in court. But they may not know that. So that is something that you would have to have that conversation with and plan with them beforehand, so they will know, so you can plan that out. Um, Improving court communication. So, of course, your automated court reminders, your text messages, your phone calls, making sure that the message that you send is clear and in simple language, and not the legal jargon. You would definitely want to include the date of their court, the time of their court, the location. And sometimes you want to, just let them know the consequences of missing court. Um, and supportive services. So using your pretrial case managements to just navigate their obligations, like I said, going into planning their child care, planning their work schedules. They're working. Hey, you have to let your employer know a week in advance that you need this day off. So going ahead and planning that with them. Using court navigators and peer support. I believe this helps instill in trust within the clients because they're working with somebody that has been through this venture with them, and that person has also helped them navigate through that court system as well. Looking at your court system, so giving grace periods, giving block scheduling. Instead of saying, hey, you have to be there at 9 o'clock, but giving them sort of a block scheduling if they do happen to be a little bit late, that a bench warrant is not issued. And one program, I think it's in Pima County, Arizona, but they have a safe surrender program. So if a bench warrant is issued, having a space for individuals to go to get that bench warrant resolved without being, placed back into custody. And if I'm not mistaken, it is Pima County, but they would, display this. They would let them know, hey, once this bench warrant is issued, you can come, and it might not even be at the courthouse. It would be somewhere different where the individuals feel more comfortable going than saying, hey, if I go to the courthouse, I know I'm gonna go ahead, I'm gonna get detained, while I'm at the courthouse. But doing it, doing it before that, it helps out a whole lot. And I think, if that county that was doing it, and like I said, I think it's Pima, they have had great success in doing that work. So again, it goes back to our first slide of, are we promoting success or managing failure? Promoting success over managing failure in the pretrial phase requires a fundamental shift from punitive oversight to proactive support. Instead of focusing on preventing negative outcomes, we should invest structures that empower individuals to succeed. And I think that, like Kelly said, that is a great way to look at individuals that we are working with, that we're looking for them to be successful. We don't want them to fail. So we're doing all that we can to make sure that they're successful and putting the right things in place so they are successful. So that is our presentation. Right now I have the QR code up so you can scan just to give the evaluation of myself and Kelly and just the material that was presented. And I will leave that up and just, Kelly, if you could just open up for more questions, if we have any more questions.
Oh gosh, we have lots of questions. Let you get a drink your water. So I'm just going to start at the top here from Garrett, and I don't want to say your last name incorrectly, so I'm just going to leave it at Garrett. What's the best course of action to address when judges set blanket conditions for all justice-involved individuals?
I think they said Garrett. Garrett, I think that will go into education with your judicial officials. and I know that's like the hardest. That's probably one of the biggest questions across the field right now is how can we get judges more on the pretrial instead of giving those blanket conditions. But um, educating by showing data, um, of what's working, educating, letting them know that if you're overly conditioning individuals, they are more likely to be rearrested because of those technical violations. Um, for us, we have been we educate all the time. We are always talking to our judges. We're always talking to our chief district court judge, just letting them know what we see and what type of conditions are coming down. Um, and I think education and providing data with your stakeholders, and just providing that monthly information to your judges will give them some ease. With the PSA, we use the release condition matrix. So when they are making those decisions, they will see, on ours, they will see the percentage of the probability of them coming back to court and not getting any new offenses.
And I don't have anything to add to that. I think you answered that perfectly. The next question is from Emily Hamilton. She said, in some counties, unsure if this applies to all, individuals may have to pay for each drug testing visit. What is recommended to encourage and support compliance for those who may have financial worries or strain in this situation? I know for our county, we definitely, that's on the individual to pay for the testing. We have worked with one of our drug testing facilities. They give a reduced rate, which I wish there was no rate at all. However, at least we get that reduced rate. And for our folks, our officers, we pay for the first 2 weeks of testing, and our officers have discretion to pay for more testing or for a longer length of time. When we first started our program, we paid for all testing, all everything. And my budget was hit pretty hard within the first 6 months. So we had to take a step back and reevaluate. That's why we settled on the first 2 weeks. But I don't know any other suggestions. James?
Yeah, I will say this, and Wendy, cut me off if I'm out of pocket with this one. Having an individual to pay for any type of drug testing or EM is about like you're having them to pay for a bail. You're having individuals that cannot make those payments, or you don't have the ones that can make the payments are going to continue to remain out free, but the ones that can't are going to be placed back in custody. Um, that would be my only thing. I don't know, how to address that with your stakeholders. And I know that takes a big budget to do. But if you could, have them not to do the drug testing and show the numbers that, drug testing is not going to impact someone's success, that would be, I think, a good route to go.
All right. From Gus Loya Cano, if I said that correctly, Gus asks, is anyone able to access these track phones? And I think that's referring to the track phones that our program has. It's really officer discretion. When the officer meets with the individual and recognizes that a track phone would help with that individual's success, they can provide that track phone to the individual. It's not blanket. Everybody doesn't get a track phone. We want to make sure that that those who need them get them. So no, not everybody. Everybody has an opportunity, but it's at the officer's discretion. I guess that's the best way to put it. I'm kind of So this question, what domestic violence risk assessment tool do you utilize, if any? We do not, our pretrial services program does not utilize a domestic violence risk assessment. I know that there's one that is used by law enforcement in our community, but we do not participate in that. James?
Our law enforcement do our what we call our lethality assessment for DV. But there is a tool out there called the Adara. As that is a DV assessment tool. LaShawn Greger, who is out of Maine pretrial, and he is he's very educated on that Adara. Kelvin Banks is also very well at getting Dr. Kelvin Banks, I'm sorry, is also very well with the DV stuff and assessment tools for those.
And it is the Odara that is used in our community, but again, our pretrial officers don't utilize that or work with that. We're not looking at the charges. We're looking at helping the individual get to court and not be arrested on a new charge. So we kind of stay away from that. We have just 3 more minutes. This one is drug use may very likely decrease a person's general stability and increase their propensity to offend. Are we sure it's not a risk factor? And James, you mentioned it's behavioral and not.
It has not shown in the studies that any type of drug use is going to increase the likelihood of them not showing up to court and not picking up any new charges. Those studies, and to be honest, at the pretrial phase, we usually don't have enough information about substance abuse to really make a recommendation that they will need it, that they would need to be drug tested or anything. If they're suspected, if they're suspected drug use or substance abuse, I would just highly recommend that they, give them some resources to get to some substance abuse centers, and just educate them on those resources.
There are a lot more questions, and I think just 2 more minutes. What is your preference, Wendy and James?
I'm fine with answering another question or two. I can say we are going just briefly, while there's still some folks on here, we will be uploading our video to the YouTube channel. I put all those links in the chat. There's actually quite a few links. And I'm looking, I was answering one of the questions related to drug testing and research. APPR has got some wonderful pretrial research summaries. I loved using them when I was working within a department to help educate my staff, myself, and my stakeholders. And so I put that link as well into the chat. The APPR research summaries, there is one on drug testing, and it does reference specific studies. And they do at APPR, they update those pretty regularly. And so that's some pretty up-to-date information there. If there's 1 or 2 more questions, I'm fine with you answering those, and then we'll close here soon.
Where do you order your phones? We purchase our phones from Walmart. Track phones cannot be purchased in bulk. I know, I've tried, and I'm probably on several FBI lists because of how many track phones are tracked back to me. But we just buy them. I think you can buy 3 at a time, and we buy them at Walmart.
And Kelly, I think someone specifically asked if that was in your budget or the judge's budget, or where that came from.
That is my budget, the pretrial services program budget. And I have a grant that helps pay for those phones.
Great, thank you. There was another one on here. Where was it? James, I think you spoke about the occupational stressors related to those monitoring EM and GPS, or at least that's how I heard it. The question was, is that related to the person's serving, like the people with the monitor on, or were you referring to staff having occupational stress for that monitoring?
I would be the person that is having it on, especially when you have the DV monitors. You have, the prosecuting witness on those monitors as well. So, that stress of just having that monitor with them at all times can cause some concerns.
Yeah. And I would add to that, and I know no one asked me, but I think we all recognize in this field that there's vicarious trauma that each of us carry. Having, been with folks most times or very often at the worst moment of their lives. And so I think especially when, and by that I mean, being arrested, being in the court system can often be the most difficult period of time someone's experiencing. And then being on a monitor and with a staff member having to monitor that sometimes 24 hours a day, or rather the person being monitored and then our
Right.
staff being in charge of that, every second in some dangerous situations, I think certainly could carry some vicarious trauma. And unless you all see some questions that you were just getting ready to answer, I think we can close. I appreciate all the wonderful, wonderful questions and feedback that you all had, and so grateful for so many of you being here with us, even just a few minutes late. Kellie and James, were there any last comments you wanted to make? All
I have
right.
none. And if you have any
Thank
additional questions for me, if you have any additional questions, I can post my information in the chat, if that's okay with you, Wendy.
Of course.
I'm
Of
happy
course.
to share my email and phone number as well.
Great. Well, thank you both. You've done a wonderful job. Thank you to all the participants. Please join us at our next webinar, if you're able, on March 6th, where we'll be going over the standards that have been recently updated. There are a bunch of resources in the chat. Please check that out maybe before you leave. This will be uploaded to our YouTube channel. And thank you so much for being here today. Have a wonderful rest of your week.